other councils have seen even more striking and concerning examples. Now, I want to refer in particular, if I may, to the situation in the London Borough of Tower Hamlets. Tower Hamlets is an authority with a directly elected mayor. The directly elected mayor is an independent, but which well known has very close connections with the Respect Party. The mayor has sufficient independent members supporting him to ensure that he has the blocking third to get the necessary budgets and mayoral policy through. But throughout that time, there has been a history of vexatious complaints against members of the opposition, Conservative and Labour parties. Labour is actually the largest party. And there has been a history of complaints being made by members of the mayor's cabinet, by councillors who the mayor has appointed to his cabinet, then making complaints, particularly against the leaders of the Labour and the Conservative groups. Sometimes those complaints have not come to fruition. In other circumstances, they have. That causes real concerns. The monitoring officer of Tower Hamlets, Isabella Freeman, is also the Assistant Chief Executive for Legal Services. And the monitoring officer is also the person who advises the mayor. And you have a situation of a monitoring officer advising a mayor, policing a regime, regularly investigating complaints by a member of the mayor's cabinet. On the other hand, complaints against members of the group who support the mayor have not been taken forward for investigation. And that inevitably raises concerns as to who monitors the monitoring officers in such cases. Now, it happens in this circumstance that you have a monitoring officer who is herself in dispute with her employer, the authority. And there is apparently an industrial tribunal case going on at that moment. But the monitoring officer still sits and carries out the functions of a monitoring officer, even though that involves councillors who may be potentially witnesses to those proceedings. We got to the extraordinary stage in Tower Hamlets where members from a number of parties passed a motion seeking to have certain disciplinary steps taken in relation to the monitoring officer. The monitoring officer, you might have thought, would have withdrawn from the meeting at that point. Instead, the monitoring officer insisted upon remaining, noting what was said by every member. That hardly gives the impression of an unbiased and open and transparent approach. Freedom of information requests have revealed that in relation to just two of those complaints, some £6,000 was spent of public money in relation to investigating a complaint against the leader of the Conservative group, some £12,000 in relation to a complaint alleged against the leader of the Labour group. No such complaints have been taken forward in the same way against the group who supports the mayor. Now, this may be a particularly egregious example, but when you see that, at the same time as members raise complaints with the monitoring officer about a highly partisan publication called East End Life, which is subject to great controversy, that same monitoring officer then responds and says that everything the mayor has put in that publication has been in order, and that same monitoring officer has given advice that the mayor was not obliged to answer certain questions from members in the council in relation to the exercise of his functions, because that might infringe his human rights. That is bringing, frankly, the standards regime that we all want to see properly and proportionately exercised into serious disrepute, and that's not in the interest of anyone. And that, frankly, seems, on the face of it, to be a scandalous matter that has arisen in relation to Tower Hamlets. And involves a particular case that I think is important, which comes back to the whistleblower point. An opposition councillor raised an issue concerning an applicant for a senior post within the council. It was demonstrated that that applicant's CV, curriculum vitae, was inaccurate in an important and a material respect. That then achieved a degree of national and regional publicity, and not surprisingly. This was someone who had been obliged to resign from a previous employment, and that was not placed upon their CV. The result of that was a complaint by the same member of the Mayor's Cabinet who is a frequent source of the complaints against that member. That was investigated. The member set out in very considerable detail their side of the matter. The hearing took place. The member was not present. That hearing took place within a matter of weeks of the abolition of the Standards Board regime. And the upshot, I have to be careful of what I say about this, was that within a matter of days of the regime being swept away, rightly by the will of Parliament, the Standards Committee, which, as I understand it, it was consisted predominantly of members who supported the Mayor, referred the matter to the First Tier Tribunal, where it remains. And the purported view of that seems to be that in relation to a complaint that was some 2.5 to 3 years old, never mind the merits of it, that there was a desire, frankly, to evoke suspension of a leading critic of the Mayor. And that was why it was being taken to the First Tier Tribunal. The First Tier Tribunal, frankly, refused to entertain it. And now I gather there may be attempts to appeal that. But that is the sort of abuse of the system which brings local government into disrepute. I think it's right to have that on the public record, because that is not a use of the system that should be intended. I hope the Minister will be able to confirm that it's clearly been the government's intention that as from the 1st of July, the ability to suspend or disqualify a member does not exist, should not be exercised in the standards regime, but that instead such a power is exercisable when the criminal offence of failing to disclose a pecuniary interest, which came into force on the same day, comes into effect. The case which we're talking about had nothing to do with any pecuniary interest of any kind, and it was actually a councillor doing what I think many people regard as their duty in pointing out something which might have been seriously misleading in relation to an important and sensitive public appointment. And the thought that that member should have hanging over their head the prospect of defending themselves in legal proceedings before a first-tier tribunal, brought, of course, at public expense, when it's known, and was known at the very time the decision was taken, that the power to suspend was going to be removed, effectively, is an abuse of the system. And I hope we can make clear and restate that that was never the intention of Parliament, that the transitional provisions that were brought into place when the Standards Board regime was abolished, never the intention of Parliament that they should be used in that way. So that, too, is, it seems to me, a very important example of where we need to look more closely at how things work. I wanted just to refer to one or two other examples, because I think it is illustrative, if I might say, Mr. Holloway, of the issues that do need to be addressed. And again, as I say,